This is Larry Jordan, the host of the Digital Production Buzz. The following interview is an excerpt from a recent program. To hear the entire program, visit digitalproductionbuzz.com. Jonathan Handel is an entertainment and technology attorney of Counsel at TroyGould in Los Angeles. He's also the contributing editor on entertainment labor issues for The Hollywood Reporter. He's got a blog at jhandel.com, and Mike and I are convinced that he doesn't sleep. Hello, Jonathan. Right. Welcome back.
Hello, guys. It's a pleasure to be back.
So the last time you were on the Buzz, you mentioned that there was a ruling against Fox regarding unpaid interns was overturned, or it was upheld, or something. What is the ruling, and what does it mean? Because now I'm all confused.
Well, you were right. The ruling that was against Fox 2 years ago was overturned about 2 weeks ago by the Court of Appeals. And the case had to do with unpaid interns on the movie Black Swan. The question was, should the interns have been paid? In general, the law requires that people who perform work need to get paid, but there is an allowance for unpaid interns. The question is, though, what constitutes a proper internship? What qualifications do you have to meet in order for someone to legitimately not be paid? Now, what the Department of Labor said, and what the district court agreed with, was that essentially, if the employer receives an immediate benefit, basically a benefit from what the intern is doing, and also, among other things, and it's a multi-factor test, but among other things, if regular workers are displaced by an intern's performing work that otherwise a regular worker would perform, that person is actually an employee and needs to get paid. The Court of Appeals disagreed and said that they wanted to adopt a test called the primary beneficiary test. Take a look at what benefits the intern is getting, what benefits the employer is getting, and see who is the quote-unquote primary beneficiary of the relationship. If it's the intern or the worker, then they are not considered an employee and can be an unpaid intern, is in essence the ruling.
So if I hear this correctly, if we bring somebody on board that's there to learn the craft and the intern is learning, then as long as that learning process is benefiting the intern, then the intern does not have to be paid. But if we're working them and we are getting benefit as employers getting benefit, then we have to pay them like we'd pay any other worker. Am I hearing that correctly?
Well, somewhat, but you can get some benefit from what the intern is doing under the Court of Appeals ruling. And it should be emphasized, by the way, that this Court of Appeals was in New York. This was a federal case brought in the federal courts in New York. So it's possible that the courts here in California would decide differently. The federal courts in California might reach a different conclusion. There is no clear guidance from the U.S. Supreme Court on the matter, and that's why you had this bit of back and forth here. Also, these are multi-factor tests, so lest I sound like an advertisement for lawyers, you really would want to consult with an attorney before deciding, gee, is this okay or not? Now, what happened as a result of the 2013 ruling was that a lot of the major studios and also companies in the fashion industry and publishing industry that had unpaid internships converted those to paid positions or ended their internship programs. Now it appears that they might not necessarily have had to do that. They're under a lot less legal threat for two reasons. One is the substance of the decision that I just explained. In other words, it's more of a balancing test rather than something that's as potentially clear-cut as the district court decision made it out to be. But the other point is a little more subtle. Because this is a balancing test that requires examining multiple factors, what benefit is the intern getting? Are they in an educational program? What kind of work are they doing, et cetera? That makes it difficult for someone to bring a class action, which is what these lawsuits were brought as, because suddenly you have an individualized person-by-person determination rather than a broad-based class action determination. So classes are much less likely to get certified, and therefore lawyers are much less likely to bring these cases at all, because the return that you get, it's simply not economically feasible to bring one of these cases for a single person. You want to bring a class action. and essentially that door has been mostly shut now.
Now, for smaller companies who are not studios, what's the advice that you would give for people that want to do interns? Should the internship be of a limited basis? And I mean, what kind of general guidelines can you give to keep us somewhat out of trouble?
Well, in general, there should be a real educational purpose and a real training aspect to the internship. So if what's going on is that people are simply making photocopies and fetching coffee, and it's a wink and a nudge, that is not the sort of program that you want. On the other hand, if what's going on is in conjunction with academic credit, and there are instructional seminars, there is instruction going on of some sort, then you're better off. But really, one needs to take a look at the decision, and obviously, the right way to do it, of course, is to consult with an attorney who can analyze that decision and look at what's proposed.
Now, if an intern is getting academic credit, he is essentially getting paid, is he not?
I'm sorry, I didn't hear what you said.
If the intern is getting academic credit, he is getting paid, is he not?
Well, academic credit is not literally, I'm so sorry, is not literally equivalent to to monetary compensation. So if someone's getting academic credit, again, you need to analyze the variety of factors that the court's looking at. But certainly getting academic credit is a major factor, particularly under the new test.
So I'm just a little confused, and this probably is a stupid question, but in California law, for instance, if you're an intern, is it the law that you must be paid, or there are variables where you don't have to be paid?
Well, there are variables. I mean, it's again, what we're talking about here is a New York federal case. California, we don't have any real guidance on this.
Oh.
So, the likelihood is that people are going to look at this and say, well, this New York case is going to be persuasive, but the way the federal courts work, they are they are regional. So unless you get an enunciation from the U.S. Supreme Court, you don't necessarily have something that's binding in other parts of the country.
It's interesting.
So there isn't a clear answer there.
When you go to high-tech companies up in Silicon Valley, the Googles and the Yahoos and things like their internships, their summer internships pay really good money, like $80,000 and housing and everything else. And these are internships, and but they're high-paid internships. So
these are companies that have the money to do that, of course, and would rather be in some cases safe than sorry, I guess. But I mean, well, there's summer jobs, right? I mean,
there's summer jobs.
And that may be a bit different than an internship per se. I mean, I had summer jobs in the computer business when I was in school, and I was expected to produce work. I created some software, or I wrote some reference manuals, things of that sort. So that's actual work for the benefit of the company. That's not per se an internship.
Well, it strikes me that
they call it internships.
We're going to be hearing more about this in the future, because it sounds like that the decision is not yet final. So additional cases are coming, or what's happening with this case?
Well, this case has been referred back to the district court under the new standard that the appeals court enunciated. The district court now has to go back and say, okay, are these particular individuals interns, or are they, or are they not? Do they need to be paid? So it'll be interesting to see what, some of these people were fetching coffee apparently, and some of them may have been getting more training. So some of them may yet turn out to have been people who should have been paid. We don't know.
Now, in the little bit of time we've got left, there's a note in my script here talking about SAG and AFTRA. What trouble are they causing these days?
Well, the SAG-AFTRA, of course, the unions merged 3 years ago now, 2012. They're in their election cycle. It's every 2 years now, mercifully, rather than every year, the way it used to be. And the candidates, in some ways, at least some of them, are still fighting the battle over merger. The folks who were opposed to merger If you read their campaign statements, they're like, merger is a terrible thing. And it's like, well,
It's done.
It's done. It's done. It happened, guys. But there is that. And then in New York, there are two slates running, but they're not running against each other. They complement each other. And when you add up, if there are 7 seats free, there was 4 in one slate and 3 in one slate. There's slates that are running essentially together, but rather than run as a single slate, they're running as 2 separate slates because some of the people are a little more SAG oriented and some more AFTRA oriented. So, guys, it is still a process, this merger thing, and it's not, we're going to hear echoes of it for some time.
Yeah, we're still dealing with the healthcare part of the whole merger, so it's, it's done, but it's not done. So,
right, the healthcare and the health and pension, and the pension plans haven't even taken any movement towards merger with joinder. So it's they're separate organizations from the union itself, and it's a process.
And
Definitely.
Jonathan, for people that want to keep track of this process and everything else you're writing, where can they go on the web?
Best place would be jhandel.com, JHANDEL.com.
And Jonathan Handel himself is that smiling face you see on the screen. Jonathan, thanks for joining us as always. A pleasure.
Thanks, Jonathan.
Thank you.
Bye-bye.
Thanks, guys.